Jackson.
My Lords and my Lady, this appeal rises from an appeal from the High Court of Justiciary and involves a case where the trial was heard back in 2003.
Yes.
The appeal was finally dealt with between, and I use that deliberately, 2012 and 2013. It contained in it what was an old-fashioned, if I may use that expression, devolution issue, in terms of the actings of the Lord Advocate being not compatible with Article 6. It was finally disposed of in 2013, in September 2013, by the opinion of that court. Of course, between those dates in 2012, the Scotland Act intervened and, first of all, defined compatibility issues in Part 4 of that Act, and went on to remove, as it were, the Lord Advocate's position in terms of the old devolution matters from the Scotland Act and from Schedule 6 of that Act. What did happen as the last piece in the jigsaw, of course, was the Scotland Act 2012 Transitional and Consequential Provisions Order of 2013,
Yep.
which had the ability, which had a definition of a convertible devolution issue. And in my submission, that is clearly what we are dealing with here. The relevant date in terms of that order was 22nd of April 2013. And Article 2 of that states a convertible devolution issue is a question arising in criminal proceedings before the relevant date, which is a devolution issue. Well, it was, and it was a devolution issue in 2012 when the appeal was before the court.
Do we have these provisions anywhere?
No. No, and the reason for that is, and I confess to that, I did not realise that this was an issue at all until I was travelling yesterday. That may be my fault, but I think it's true of my colleagues, assumed it was accepted that we were dealing here with a convertible devolution issue.
But for those who may not be imbued in devolution issue jurisprudence, it would be helpful to have some guidance as to what exactly the statutory jurisdiction of the court is.
Indeed. Well, I have copies for everyone here of that section of the Scotland Act Transitional and Consequential Provisions, which I've been very kindly handed by someone on the other side of the table. Thank you.
There'll be more. I presume we're also going to be provided with with Part 4 of the 2012 Act.
Thank you.
Or at any rate, the provisions that are in Part 4 that we're going to be asked to apply.
Indeed. Indeed. If I could look again at that Article 2, a convertible devolution issue is a question arising in criminal proceedings before the relevant date, which is a devolution issue. Well, this was clearly a devolution issue and was dealt with as such by the High Court in Edinburgh and was obviously being dealt with before the relevant date. Would have been a compatibility issue had it arisen on or after that date, and it would have been because it falls within the definition of a compatibility issue as contained in the 2012 Act, and certainly has not been finally determined before the relevant date, and the determination of the court was in September 2013.
Now, look, of course, The expression devolution issue is defined in the 1998 Act.
It is.
And the expression compatibility issue is defined in the 2012 Act.
It is.
But we may have to look at those.
The compatibility definition is contained in section 34 by reference to including it inside the 1995 Scotland Act. And the definition of a compatibility issue means a question arising in criminal proceedings as to whether a public authority has acted in a way which is made unlawful by Section 6.1 of the Human Rights Act 1998. That is all that I need to refer to for these purposes.
What's that?
Section 6.1 of the Human Rights Act 19...
No, no.
Oh, I'm sorry. It is Section 34 of the Scotland Act 2012,
Yeah.
which introduces a Section 288ZA into the Criminal Procedure Scotland Act 1995.
And do we have these?
I certainly have them here. I have my copy of that. I do apologise for this. I simply did not realise this was an issue.
Well, we did ask.
Well, I was in, yes, that's true, but I was in transit at that point.
No, we asked when leave was given.
If you look at the terms on
Did we
which
not?
leave is given.
No, I don't think so.
Well, we'll come to it, but one matter we did ask to be addressed on was retrospectivity.
Oh, yes, of course, I understand that. I understand that. Of
All
course,
right.
that's right.
However, we do need these provisions.
Okay.
Some of us have looked at them in the past, but we need them in front of us in order to apply them in this case.
Yes, they were laid out in detail by Lord Hope in the case of O'Neill, where he went through all this, and I had thought this was a settled matter. And for that, of course, I was clearly wrong. But they were laid out in the case of O'Neill.
Yes, but not everybody is in every
I
case,
appreciate that.
or has the materials, or recalls every case, even if they were in it.
I appreciate that. I will...
But what you're saying is you didn't realise this was a relevant issue till it was drawn to your attention, at which point you were in transit.
Absolutely. That is my absolute position.
Yes. Not a problem, we just need the materials.
Yes, I appreciate that.
So where are we going to get it?
At this stage, and I will supply, but let me just read the very short section I was reading.
O'Neill, you say?
O'Neill or McNeill?
O'Neill.
O'Neill, which we haven't, I think.
And in
met.
paragraphs 4 to 9 of that, I don't think it's in there, but paragraphs 4 to 9 of O'Neill, Lord Hope laid out how the Scotland Act, he laid out in detail the changes the Scotland Act of 2012 had brought into the issue of devolution issues and compatibility matters. But a compatibility issue is a question in criminal proceedings as to whether a public authority has acted in a way which is made unlawful by Section 6.1 of the Human Rights Act.
It's just, I'm afraid, impossible.
we have to have copies of the Act. We can't sort of think about, properly understand it unless we've got it in front of us.
Yeah.
Public authority.
I think what we'd better do, can you tell us what provisions you're going to refer to?
I am referring to the Scotland Act 2012.
I know you're referring to Scotland Act 2012, and
Sections 34 and 36.
right. What else are you going to refer to?
What I think you have, which is the consequential provisions.
Yep, the 2013/7 order. Right, so that's what you're referring to.
Indeed.
Right. Mr. Brown, are you going to be referring to any other matters that we haven't got copies of in this connection?
My Lords, the Crown obviously were in transit also, but have managed, I'm afraid, despite the Crown Office's technology, to achieve some copies.
But yes, what are you going to refer to?
Well, I think 2013/7.
213.7,
You've just been given copies
which
of.
we have got copy of. Anything other in it that we haven't got copies of, apart from section 34 and 36 of the Scotland Act 2012?
I think 57.
57, Section 57 of the 1998 Act we will obviously need, and probably Schedule 6 as well.
I think the sensible thing is for us to adjourn briefly so we all have copies of the relevant sections. And that's what we'll do. Very well, we'll adjourn now and come back as soon as we've got copies of these. Have you got copies of all this?
I do.
Well, I suggest you give them to the usher and he will copy them. Thank you.
I don't like that either.
Right, I hope we've now got what we need.
I hope so, my lords.
Good.
Returning to the issue as to how this becomes a compatibility issue to be dealt with within the jurisdiction of this court. The original devolution material is contained in the Scotland Act 1998, first of all in section 57.2, dealing with a member of the Scottish Executive has no power to do any act, I'm reading short, as far as that is incompatible with any of the Convention rights. The Lord Advocate is, of course, a member of the Scottish Executive, as it was then called. Schedule 6, Part 1 of the same Act defines a devolution issue.
And where do we find that?
You have it, I hope.
On the second page of
You have it, I hope.
Yep, we have it at the second page of the bundle on the bigger bundle on the Scotland.
Copied, I think.
Yep, thank you.
A devolution issue means, and then there are a number of things it means.
And which one do you rely on?
It would be number C.
Thank you.
A question whether purported or proposed exercise of a function by a member of the Scottish Government is or would be within devolved competence. And prior to 2012 or 2013, when actions of the Lord Advocate as being contrary to the Convention were complained of, they were taken as devolution issues, which is precisely what happened in the present case in about 2012. And the Edinburgh Court in Macklin clearly dealt with them as what they were, devolution issues, old style, if you like.
Yep.
The Scotland Act 2012 made significant changes, particularly in sections 34 and 36 of that Act.
Thank you.
Section 35 doesn't need to concern us at all. Section 34 defined a compatibility issue as to whether a public authority has acted or proposes to act in a way which is made unlawful by Section 6.1 of the Human Rights Act 1998. Now, you may not have in front of you the Human Rights Act, Section 6, but it's very simple to read that. It's very short.
Yep.
It simply says it is unlawful for a public authority to act in a way incompatible with Convention rights, and a public authority is any person certain of whose functions are functions of a public nature. I do not imagine it is a matter of dispute that the Lord Advocate is a public authority and therefore falls within the definition contained in a compatibility issue. The Act then did two other things by Section 36. First of all, it amended the Scotland Act, Section 57, by taking out certain words, the effect of which was to remove the Lord Advocate when he acted in a way incompatible with the Convention from the devolution, those provisions which were
Understand.
in force at the time. So in fact, what then happened was, and the reasoning I think was the present situation is thought to be less cumbersome, what then happened was the action of the Lord Advocate were no longer to be seen as a devolution issue, but were to become, in terms of the definition in the New Scotland Act, a compatibility matter.
Which is the section that has that effect?
I'm
Section
sorry,
36.
36.
36.2. Yeah.
By omitting the words after paragraph B.
Yep, which because of subsection 2, etc.
That's right.
Yep, okay.
So that had the effect of taking the same actions, if you like, of the Lord Advocate, but they no longer were a devolution issue. They were a compatibility matter. And Section 288AA of the 95 Act, as put in by Section 36,
Yep,
was the section dealing with appeals to this court on compatibility issues.
yep.
And that is actually in your papers, as it happens. Wonder of wonders, that is in your papers at Appendix Part 2 and at the very end of that.
Thank you.
It is at page 130 or MS page 218.
So we have that twice, photocopied for today and at the end of the month.
That one was in your papers as it happened.
Thank you.
So that was the system which moved the action of the Lord Advocate from one setup to another setup, and the only missing part of the jigsaw was the need for transitional and consequential provisions, which you have, and which I began to quote this morning. The key date, as I've said, was the 22nd of April 2013.
Yes?
And a convertible devolution issue was something which, before the relevant date, was a devolution issue, which this was and had been dealt with by such, no one disagreed, would have been a compatibility issue had risen on or after that date, which it would be because of the new regime, and had not been finally determined before the relevant date, which it hadn't, because the opinion of the court in Macklin was issued in September 2013. So that, I hope, is the answer to the question about this court's jurisdiction in a matter of compatibility.
So the nature of the issue is unchanged
The nature
by
of the
the
issue is
2012
absolutely.
Act, but the issue just, as it were, changes its name.
And I'm not suggesting one does this, but if one reads Hansard, which I happened to do last evening, for the reasoning behind that, it was thought to be cumbersome and just easier to deal with. I'm not sure I understand the reasoning entirely, but the reasoning given by the Minister was it is thought to be an easier to understand and less cumbersome system.
Okay.
I'm not sure that's right or wrong, but that's why they did it. But my Lord in the Chair is entirely right. It's the same thing under a different title.
Thank you.
So coming now, as it were, to the issue itself,
Yes.
if I may do that. And there are really, what is complained of in its entirety is the action of the Lord Advocate in the conduct of the trial, or the whole conduct of those proceedings, and it arises in two ways. And I don't separate them finally, but they are two separate aspects of what is complained of. One, the first one, is the disclosure issue. And the second one is what I might call the issue of doc identification.
Understood.
The disclosure issue is a situation where it is accepted, and I don't go through the detail of this, there were details and statements of 6 witnesses, potential eyewitnesses to various parts of the proceedings, which were not given to the defence. And on top of that, there was a fingerprint, a particular fingerprint, more than one, but a particular fingerprint of a man called Pirrie, which was not given to the defence. And the first question for this court is perhaps, although I don't linger on this question for reasons that will become apparent, whether or not all of those should have been disclosed, because it is my submission, it is clear that all of that material should have been disclosed. I look at, for example, the Crown response to this matter, and the Crown response begins almost with the statement, it would all be disclosed now. So under the present regime, the Crown would disclose all of these things, and I hope I'm quoting it right. If I'm quoting wrongly, I apologise, but that is what I remember from the Crown submission.
I understand.
Where does one find that? I've lost my code. It's in the core volume and the case for the
page 71.
Case for the respondent. That's
MS
it.
71.
It is
Paragraphs
accepted.
5 and 6.
Yeah.
Would, without question,
Yeah, no, that's-
be disclosed
Yep,
to the
we have
defence
that.
under current practice.
Yep.
And it's difficult for me, and it's not a matter for me, of course, but I suggest it's difficult to work out why it would be appropriate to disclose it now, but not have been appropriate to disclose it in the past. I accept, of course, that it might not have been a regime to do that in the past. And my simple answer to that is, and the test, of course, for disclosure, let me just add for completeness, is in the case of McInnes, which is at tab 7 of your authorities.
Yep.
And indeed, it is Lord Hope in the very first paragraph. And there's no dispute about the test. I think you will find in both my case and the respondent's case that is there. But he begins with the words, the law as to the duty of disclosure is now reasonably well settled.
Yes.
And he goes on to deal with that, which would tend either to materially weaken the Crown case or materially strengthen the case for the defence.
Now, the appeal court applied that test.
Well, I need to come to that, if I may, my Lord, when I come
Okay.
particularly to the next part of it.
Yep.
Because while there are two quite separate stages in the process, there is a degree of overlap. Sometimes this material you use for one is the same material as you use for another. So while I accept there are two stages, there is a degree of artificiality in that there is a definite overlap between them. The simple answer for me, for my submission, is that if it would be disclosed now, it should have been disclosed then, and I would submit to this court, that one way to look at it in a very simple way is to say there is, I use the word with care, almost a class of material which should be disclosed. So if you have eyewitnesses, it is difficult in my submission to see why you would not have a duty to disclose the existence, at least, of eyewitnesses. I come later to a matter of preparation, which Lord Roger deals with at a later stage in another case, but the existence of eyewitnesses. So too, if there is a fingerprint of someone who is known to have tendencies, if I may put it that way, to commit this sort of crime in a situation which might be relevant to the crime, it is difficult to see why that should not be disclosed. But if I may move on, because there is an overlap, if they should be disclosed, that of course is not the end of the matter, because there is the second stage of what might be called the McInnes test, and that is the consequence test as to whether or not disclosure, the failure to disclose, amounts to anything, if I may put it that way. Now, if I could take the court back to McInnes, where that test is laid out, it is laid out repeatedly in the case of McInnes. First of all, at paragraph 20. still dealing there with Lord Hope,
Yes,
where he begins, the second question is directed to the consequences of the violation. This arises at the stage of an appeal when consideration is given to the appropriate remedy, etc. And then at the bottom of that paragraph, the test that should be applied is whether, taking all the circumstances of the trial into account, there is a real possibility that the jury would have arrived at a different verdict. You will find that repeated in other language, but pretty much the same point at paragraph 24, where he puts it this way: if the jury, at the very end of that paragraph, if the jury might reasonably have come to a different view on the issue to which it directed its verdict, if the withheld material had been disclosed to the defence, which I take it as saying the same thing, only in a different way. That test is affirmed by Lord Roger at paragraph 30, where he points out not every infringement necessarily means an unfair trial.
yep,
And he repeats the same test. The appellate court will only hold that a trial has been unfair if there is a real possibility that if had been disclosed, a jury might reasonably have come to a different verdict. I notice sometimes the word could is used and sometimes the word might is used. I tend to the view that it makes no difference, because what rules is the phrase a real possibility. A real possibility that something could happen is just another way of saying it might happen. Although I notice the language is sometimes used in different ways, but I wouldn't make much of that. And Lord Brown at paragraph 35 reaffirmed this matter. In short, the appeal should be allowed if the court decides that had defence counsel been in a position to make use of the undisclosed statement, the jury might reasonably have come to a different conclusion. So we've got one could and two mights, but for reasons I've given, because of the ruling phrase, the real possibility, I'm not sure that makes much of a difference. I now turn, of course, to what the Crown say happened, because we are not disputing the test. I think the Crown and I would be at one on the test. And we come, I suppose, to the point which my Lord Reid has raised with me, which is that once the test is applied, how it is applied is, if I may put it respectfully, of little business of this court, which I think is the point which is being made to me. And I accept that as a general proposition because, of course, there is authority to that extent. And we must never, as we've often been told, forget that the court in Edinburgh is the final court of appeal on certain issues. And I accept that. But I point out two things in that. First of all, interestingly, in the opinion given in the case of Macklin, at no time does the court say it was applying that test. Now, I notice surprise.
Are you sure about that, Mr. Jackson?
I'm sure of nothing after all what's happened this morning, but I think that's right. I think, I don't think the court does say it. The court says later, when it refuses leave to appeal to this court, that it had applied that test. The court says some weeks later, that's the test we did apply, but in the opinion of the court in Macklin, I do not see them saying they were applying that test. I can see the Crown telling them that was the test, and I can't refer you to a passage because I can't refer you to where it's not. But I can see a look of surprise in that, but I haven't found it, where the court says it was applying that test. But secondly, assuming I am right for the moment in that, and I see others looking to see if that's right or not, but assuming I'm right for the moment in that, eventually the court here has to look at...
Well, we have, in paragraph 33,
Yes.
they're applying the test taken from paragraph 1 of McInnes for whether or not disclosure was necessary.
Yes.
And in paragraph 37, last sentence, they're applying the test as to the consequences of non-disclosure from paragraph 20 of McInnes, aren't they?
Well, I'm simply saying, and I'm saying no more than that, and of course my Lord Reid may be well entitled to take that inference. At no time does the court in its opinion state that's the test it's applying. Makes no reference to McInnes.
Well, paragraph 33, this is dealing with Pirry's, the fingerprint, but then they also apply this to the evidence of some of the eyewitnesses, the statements of some of the eyewitnesses. And they say it did not constitute evidence which materially weakened the Crown case or materially strengthened the defence case. Now that's the paragraph 1 of McInnes' test.
Perhaps I'm splitting hairs by simply pointing out it is not specifically said.
What's your point that they didn't refer to McInnes?
I thought your point was that they do use the wording of part 1 of the McInnes test,
Yes.
but they don't use the wording of part 2 of the McInnes
Well, they
test. I
do
thought-
use the wording, as has
But
been
they do,
pointed out.
yes.
They do use the wording. I can't avoid the fact to use the wording.
Not persuaded that had such evidence been led, there would have been any real possibility of it persuading the jury to return a different verdict. That's 33, and then at the end of 37 there's the same
They
phraseology.
do
used.
refer to McInnes in paragraph 23, albeit through the advocate depute submission.
Indeed. Well, perhaps if it is thought I am splitting hairs on that, then perhaps so. But in the end of the day, it cannot be enough for the court to even say we are applying the test. This court must be entitled to look at how that test was applied. Now, that's a matter of degree and where a line is drawn, but could I turn you, please, to McInnes at paragraph 25?
Yes, of course.
Although I have suggested that the description of the test which the Lord Justice General gave at the end of paragraph 20 was incomplete, it appears it is clear from the discussion that follows that the test that the appeal court actually applied was the correct one. Well, let's assume that's the case here. As I have already observed, it is not for this court to say whether the test was applied correctly. So far, that's right. But it is open to it to examine the reasons given by the appeal court for concluding that it had not been a miscarriage of justice, to see whether they show that it applied the correct test. And then he says, having considered what the Lord Justice General said, I am entirely satisfied on this point.
So you can look to see what they've, what their reasons are in order to see whether they've really done it. Is that it?
It's a kind of circular argument, I accept, but yes, that's what I'm saying. Otherwise, it would be open for the court, and I'm not saying for a moment the court in Scotland would ever do that, to pay lip service to the test and say, as long as they say the magic words, that is the test, they could clearly, nonsensically, I'm not saying that would happen, apply it. So there has to be a limit. One has to take the balance, I suggest, which Lord Hope has, which is, yes, the test is there and it's not for this court to go against it, but you're still entitled to look at all the facts of the case and say, never mind the lip service to the test, did they actually really do it in a meaningful and rational way? And in my submission, when you conduct that exercise in this case, it is the conclusion arrives that they did not, albeit they say they did, in terms of the words which my Lord Reid has pointed out they used. The Crown go on to say the same issue would arise in any event because it is not really a different case that we are dealing with here. And I'm not going into the detail of that, but the Crown point to the case of Fraser, which was, of course, before this court, where this court said it is not for the appeal court, as it were, to reconstruct a new case. It's not for the appeal court to say, well, even if that hadn't happened because it was wrong, there would still have been a different and new case, and it is not for the appeal court to do that. And I accept that, and Fraser was a very peculiar case. But inevitably, when you look at what would happen with disclosure, it is not the same case. There must inevitably be a difference in the case. The Crown say in this case there would still be an alibi. Well, of course there would still be an alibi. I leave aside for the fact there would also have been an incrimination. We come to that point separately. But there would still have been an alibi. And what the Crown main submission is, and I quote, I think, from their submission, although they can do it themselves, they state the defence position is not strengthened by other witnesses giving similar evidence. Now, I totally disagree with that statement, that the defence position would not be strengthened by other witnesses giving evidence. It depends on the quality and who and what the witnesses are.
Mr. Jackson, are you now on whether the Court of Appeal applied the right test, even though it said it did?
Yes.
Or are you on whether they came to the right answer?
I'm really on the former, albeit I'm also on the second. Of course I'm saying they didn't come to the right answer, and of course these matters overlap. But if I simply put it as the second and no more, then I peril myself. So I'm not about to do that. So I'm still on the situation where I'm saying not only did they not come to the right answer, but so manifestly did they not come to the right answer that this court, in terms of paragraph 25 of McInnes, is entitled to say the proper test was not applied.
I think what you're trying to do, Mr. Jackson, if I may say so, is to reopen a door that was firmly shut in McInnes. What they were saying was that this court has to be spared the ordeal of examining the reasons given for the application of a test by the court below, as long as the court below was clear in its mind as to what the test was.
Well, I understand that's the argument against me, but I'm back. My Lord Gill says that McInnes closed the door and I'm trying to reopen it. Lord Hope says in the closing paragraph, it is open to this court to examine the reasons. It is open to this court to examine the reasons. Now that must mean something. He's not saying, and by the way, we cannot examine the reasons. He's saying the opposite. He's saying it is open to this court to examine the reasons. Therefore, it's what I'm inviting this court to do. Not just, as my Lord says, to suggest they got the wrong answer. Of course, that is what I am saying, but I'm saying it in a different way.
Yeah. But he goes on, he continues, to see whether they show that it applied the correct test. So that's the issue. Did they actually apply the McInnes test?
Yes. And you could have a situation, as I say, is here, where, as I've pointed out, you could look at what they did and say, you couldn't, it is so, if I may put it this way, manifestly wrong. You couldn't have been applying the right test because it is an unsustainable position. And that is what I suggest the Lord Hope is saying, that you cannot claim, you cannot just have lip service to the test. It has to be more meaningful than lip service. And that's the danger. If you close the door completely to examining the reasons behind it, then a court, not that it ever would, but a court could say, here's the phrase, here's the mantra, and then do what it wanted. And that is not appropriate. And that is why I suggest the Lord Hope says it is open to this court to examine the reasons.
But assessing the weight to be given to particular undisclosed evidence can only be on the wrong side of the line, surely.
I'm sorry, I didn't follow.
How does it help to identify what test they applied, what weight they thought should be attached to evidence such as corroborative evidence in
because if one looks
statements?
If one looks at what we have here, I'm going to suggest when I do that it is manifestly clear that applying the test could only have been lip service because it is so manifestly wrong.
Sorry.
Sorry.
Taking stage, the fingerprint bit. The fingerprint.
Yes, I'm coming to that, yes, of course.
I mean, can you say, when one looks at the first part of paragraph 33 of the High Court's judgment, that he did not ask themselves the right test?
It's the difference between saying you're doing the right test and it being so manifestly wrong that you weren't.
Well, that's not actually an answer to my question.
Sorry?
It's not really an answer to the question.
Sorry.
I mean, they say there, in our opinion, it did not constitute evidence which materially weakened the Crown case or materially strengthened the defence case.
Well,
Now, you disagree with the conclusion they reached on it. You said, oh, no, well, actually, it did potentially weaken the Crown case or strengthen the defence case because the defence could have said that this was material for putting Pirrie firmly in the frame, to which the counter-argument is, but it wouldn't have helped to put Pirrie in the frame because there were three men who carried out the crime. That all goes to merit, but my question is a rather simple one. When they say, in our opinion, it didn't constitute evidence which materially weakened the Crown case or strengthened the defence case, can you really say that they didn't apply the correct test?
what I'm saying is that even if you say you're applying the correct test, if your decision is so manifestly absurd, and I'm not saying that is the case here, but in that situation, that is why there are occasions where it is open for this court to examine the reason.
What you're saying is that they can't just, as it were, so you can't be fobbed off simply with the point that they said they're applying the test. And you say that properly analysed, they couldn't have been applying to the test because if they had done, they wouldn't have come.
Absolutely.
Right.
Absolutely.
Have that point, thank you.
Absolutely. But I want to say why that is.
Oh yes, please, of course you do.
If I may go on to that.
No, we
Because the Crown say you just had more witnesses to the same thing. Now, that is not right. The two witnesses who undermined the identification, I'm not going through the detail of the case, but the two witnesses who undermined the identification were a man called John Ronald, and a man called Michael Reid. John Ronald was a villain, if I may put it that way. He was certainly a man who consistently denied police statements, denied everything, not a man of any credibility whatsoever, on any view. Michael Reid was not, but there's a rather interesting comment in a parole report, I think, of where I read it by the trial judge, that he betrayed signs of a nervousness, which clearly I can only take it was meant to suggest something adverse towards him, although why being nervous in a witness box is adverse, I have no idea. But there was these two witnesses, and undoubtedly the defence had two witnesses who would say that. But then add to that what was not disclosed. There was one child who could identify, so the child said, and was never asked to identify. Never asked. There were two other children.
This is the little girl.
That's the little girl. AJD.
Yep.
Alicia Jane Douglas is her full name. She was a little girl. She was 9 years of age. She said she could identify, and she was never asked to do that at all. There were two other children who were shown photographs. The boy, Jimmy Johnson, saw the person coming to the door of the passenger side and picked out someone. And it was accepted that that person had absolutely no connection. So that's the second one. Right. He was a boy of 11.
This is when the cars are banned rather than when it forms the escape, yes?
That's right.
Right.
The third one was a boy called Harley Ross, another 11-year-old, who said he saw the passenger in the vehicle, said could identify, was shown a photograph and did not identify. On top of that, and those are the ones which it is said, it is conceded by the Crown, should have been disclosed. No one's saying they should not have been disclosed.
Understood.
On top of that, there was an adult male called Hunter who saw the chase to the car and gave in his statement important information about the level of distance between the chasers and the person being chased. So he had a value. There were two others, a man called Taylor and a man, GC, I forgot his name, a man called Campbell.
Yep, GC, yep.
Who are of less value, but I come back to that, who were not able to say they could identify anyone.
Yep.
So what you're adding here, the two witnesses who disputed identification are children who presumably are not dishonest, they may be unreliable. One could identify never asked, two could identify said it wasn't him, an adult man who changed the distance. I note in passing that in Macklin the court say, but would counsel ever have led these children in case they identified in the dock? I have to say, as a defence counsel, I can answer that. Counsel would have led the children. The appeal court, with its experience, might think they wouldn't, but I can say they would have led those two children, I would imagine. But on top of that, there are two other witnesses who would have been further investigated in terms of their ability to tell exactly what happened. And in McInnes at paragraph 28, I think, and also in Holland we come to later, the need for disclosure is to have material necessary for the proper preparation as well as the proper presentation of his defence. That's an exact quote from paragraph 28, and I think he repeats that in a case we come to later of Holland at paragraph 72, just for completeness of reference. So what we have are 6 potential eyewitnesses. Some of whom are clearly supportive of it wasn't the man, and others who certainly would have been of value in the preparation. Now, what I say is just looking at the witnesses alone, and I know I need to go as far as this, to say that that material would not have been of such value as could reasonably, possibly could have affected the outcome is so wrong and so lacking in logic and is so absurd. And I put it like that we are entitled to go to paragraph 25 of Lord Hope's opinion, where he says it is open to examine the reasons.
Right.
And it's a line drawn. I appreciate there will be some cases where this court might say, well, that's not what we would have done, but it's not so far out that we can change it. And it's very difficult to know in any line exactly where to draw it. But what I say is there has to be some cases where it is so absurd, the conclusion, that this court is entitled to say, never mind what was said about applying the test, it was not in reality done.
Very well.
And that is my position on that alone.
Thank you.
That is...
Mr.
Sorry.
Jackson, does that mean then that on this revised view of McInnes that this court would have a function if it met your test of absurdity?
That's one way of putting it, yeah. But, I mean, I'm not sure absurdity is the right word, but I'm making the point, I think, that it's just manifestly not sustainable. And if I'm wrong in that, and obviously my Lord Gill says that is reopening a door, yep. I say I'm not reopening a door, I'm saying that is the door that is open in paragraph 25 of McInnes.
Yep. Thank you.
Has to mean something, but it is open to this court to examine the reasons. Has to mean something.
Thank you.
Then allied to that was the fingerprint evidence. Now again, I begin by looking at the Crown position. The fingerprint of the man called Perry was on the passenger side of the rear view. I'm not sure if it was on the passenger side or not, it was certainly on the rear view mirror.
Yes.
It was on the rear view mirror. And I come to why that is of huge importance in due course. Now, the Crown say that if we had given you that, and this is the point being made to me a moment ago, that would have given rise to serious risks. There might have been a second man anyway. You already had his name mentioned in the case, although no basis to do anything about it. Indeed, the man who is said to have mentioned his name denied ever doing it, so there's no evidence of that. Therefore, they say you could have looked into that already, but what I say is this. All evidence is double-edged. It is not an answer for the Crown to say we would have made suggestions counter to that. the great mystery of criminal trials is everything is double-edged almost. One way or another, things are double-edged. So the Crown may well have said what they're going to say.
Yeah.
But, in my submission, the presence of that print changed everything. And I say why that is. It is accepted that the person who ran away was the passenger in the vehicle.
Is it?
Yes,
Right, thank you.
it is. And the reason for that is because the police said the vehicle just moved as he got there, sort of thing. So it was, the general view was, it was certainly open to the jury to conclude that he was the passenger in the vehicle.
Yep.
It is on the passenger side of the mirror. I'll try and get someone to find exactly where that comes from for you.
But even if it is, who's likely to touch the mirror?
Well, I give you an answer to that. If one's looking at likelihood, you're a villain going away, and you jump into the passenger seat, and you are interested in whether you are being followed or not, you would well touch the mirror.
I see.
And one might ask, why would the driver need to touch the mirror? Because he's already got the mirror fixed.
Well, why the assumption made that the fingerprint arrived at the moment of the chase?
Absolutely not. You can't actually.
Much more likely to have been when whoever the driver was adjusted it when he first got into the car, isn't it?
It's possible. I mean, obviously, I accept that. Everything has got a double-edged argument, and that's the point I made earlier.
It's not quite a double-edged argument. It's what's its probative value at all.
Well, indeed. But what is important, if he was the driver of the vehicle, he's obviously touched the mirror, but there is no fingerprint of him on the wheel. Now, it is strange that the only fingerprint recovered of him is from the mirror, because if he is leaving a fingerprint on the mirror, why, one asks oneself, would he not leave a fingerprint on the wheel? And there's no fingerprint on the wheel recovered.
Well,
But
the general proposition, Mr. Jackson, in relation particularly to fingerprints and the like, is it not, that the absence of evidence is not evidence of absence?
no, I accept that, but nevertheless, I'm looking at a whole picture.
I see.
But what does happen is Perry, and this is not a matter of dispute, there is at least a basis for saying that Perry was in the passenger seat for the reasons I've given in terms of fingerprint. Perry is a man of the same ethnic background, of the same height, the same age, and is also a man who is a villain in the terms of his background and previous conviction. None of that is speculation. So what we have is the Crown not revealing the fingerprint of a man like that consistent with him being the passenger. Now, as my Lord is pointing out, there are other ways of arguing it. There would be double edges. There would be ways the Crown could counter it. But when one puts these two together, in my submission, we are clearly in the category where you cannot rationally apply the test and get to the result that was got to.
Can I ask Mr. Jackson? I mean, at the end of the day, because this is now a compatibility issue,
Sorry,
because this is now a compatibility issue, this court doesn't determine what actually is the outcome of the appellant's appeal. It simply, as I understand it, would determine what the correct legal test was for the appeal court in Edinburgh to apply, and then remit the case to it.
yes.
So, presumably, presumably, we would be invited to repeat the test which we've seen already in McInnes, and remit to the appeal court to apply it again.
Yes, but your reason for remitting it back would be that the reasons given were such as to open the door that I've mentioned. Now, my Lord Reid might be right. The appeal court could just repeat its error, if you like. But that would be a strange thing for it to do if this court has said what I'm asking this court to say. Because theoretically we could go around in a circle for years if we did that.
Yeah. So, I mean, I'm looking at the way Lord Hope approached it in McInnes, at the end of paragraph 18, was to say that the question as to what the correct test is forms part of a devolution issue. So that's now part of a compatibility issue for us. So we would determine that question, and we know the answer. There's no dispute as to what the correct answer is
to
that. And so really the only thing we would do is just send it back and say, redo the exercise.
Yes, but you would say why. You wouldn't just send a one-liner saying, do it again, please. There would be a reasoning of the court as to why they considered the test was manifestly not applied. It would be difficult for the appeal court then to simply do the same again. Nothing, of course, impossible, but that'd be a bit tricky. So my Lords will be given the reason. And I say that those disclosure issues, and I just pin this down to the wall for a moment, would in themselves be enough. When you add the witnesses and the hand and the fingerprint, that would be enough to overturn the decision of the Scottish Appeal Court. And then, of course, we move to the other matter, which is the dock identification. Because it's all cumulative, as I will come to eventually. It is all, although I'm taking these as separate issues, as is pointed out in due course in Holland, it's all cumulative, this sort of situation. The general principle of dock identification, again, are not difficult to take, and they are in Holland, first of all, at paragraph 5. Which I think is, again, Lord. I'm just looking to see if any members of this court were there. Yes,
well,
one. I was having,
yes.
I was having a look to see. I'm sorry, I couldn't remember. Paragraph 5.
Yep.
There is the Lord Hope, where he says he would reject any suggestion that the use of dock identification must always be regarded as incompatible with the accused Article 6.1 Convention right to a fair trial, even if Scots law is indeed unique in that regard.
Yep.
And for the avoidance of doubt, I'm not trying to overturn that statement. I'm not wanting to argue that it is that is the situation. He adds at paragraph 9, a decision in this case demonstrate the limits beyond which the practice of dock identification cannot be taken without risk to the accused Article 6.1 Convention right to a fair trial, but it should not be taken as a signal of the practice of inviting witnesses to say whether the person to whom they're referring is in court, and if so, to identify him, is itself objectionable. Lord Roger deals with the matter at more length, I think, and I begin, I hope, for reasonable completeness at paragraph 41.
Yep.
These authorities show that the proper approach is to consider whether, and I emphasise the next words, having regard to all the elements of the proceedings, including the way in which the identification evidence was obtained, the accused had a fair trial in terms of Article 6. While one cannot exclude the possibility that in an extreme case the judge could conclude that admitting dock identification evidence would inevitably render the trial unfair, normally the requirements of Article 6 will not raise any issues of admissibility. In effect, therefore, the last sentence, the issue will generally be for the appeal court to determine after considering all the relevant aspects of the trial. That's very important, because what he's saying is one has to look at it, as it were, with hindsight, and look at all the elements of the trial.
Well, evidence might be admissible, but still leading it might lead to an unfair
Yes, of
trial.
course. If I may use a great phrase, in all the circumstances, just depending on what the whole package was.
I find this very odd. I mean, one can see that a failure in disclosure is a breach of Article 6.3 of the Convention. And so prima facie, there's, at the trial, there's a breach of Article 6.
Yes, of course.
Edwards tells us that prima facie breach can be cured on appeal if the material is then disclosed and taken into account by the court. And that, I mean, that's perfectly orthodox Strasbourg jurisprudence. What's odd is saying that the admission of a particular type of evidence or the presence or absence of particular directions to a jury is something that Article 6 has anything to do with.
Well, if I could come to that, if I may, but these things are not in isolation. These are not separate Article 6 issues. I'm not saying, for example, that a failure to give a jury direction is in itself, and I hope we will see this as I go on, is in itself an Article 6 point. It is the point that Lord Roger makes repeatedly, which is looking at the whole package, if you like, looking at all that happened in the case. You have to not say doc identification is good or bad. You're required to look at it in the context of what hindsight tells you about the whole case.
Well, that's the sort of thing a domestic criminal appeal court does. Is that something to do with Strasbourg? Or you know,
what I'm saying
the European
is,
Convention?
well, in Holland, as we will come to, it was one of the factors which this court used to strike at Holland. And again, it's very similar to this case because Holland was a combination of disclosure and doc identification. Now, my Lord may disagree with what this court did in Holland, but you'll forgive me if I don't in that particular situation.
Well, I'm wondering really what Holland is to be taken as having decided. Is it really a disclosure case?
It's not just a disclosure case. No, it's not. No, I think as we see, it's not deciding disclosure or doc identification. It is deciding if the actings of the Lord Advocate were incompatible with the right to a fair trial and looking at all the circumstances, including disclosure and the doc identification. I'm not going to accept that one as it divides them up in the way that you're suggesting. It's an overall looking at it.
But my understanding is, Mr. Jackson, that you complain about the doc identification by the two policemen because they hadn't undergone an identification parade. Is that
Not entirely. It's more than that. I'm saying that I'm complaining about the doc identification with the value of hindsight, looking at all the circumstances. I'm not being tied down, as it were, to one thing in that, and I'm going to come to them all in due course.
Does that cut both ways? I mean, you're founding on two negative doc identifications, if I understand you. Are those ones all right, or can we consider whether they're reliable?
Everything cuts both ways. It's the nature of...
I think you've got to say that, Mr. Jackson.
Everything cuts both ways. It's the nature of the business. Everything cuts both ways. Could I come back to the Lord Roger, because what he does, having laid that down, he then, in a very normal and sensible way, of course, as one would expect, from paragraph 47 onwards, he deals with the dangers of doc identification. But these are well known. These are just common sense dangers which have always been known in terms of doc identification. But if I could take it back up, please, for the important section from 57 onwards. I respectfully agree that, except perhaps in an extreme case, there is no basis for regarding such evidence as inadmissible per se. The safeguards to which the Lord Justice Clerk draws attention, the requirement for corroboration, the opportunity for counsel to contrast the failure to identify at the parade with the identification in the dock, and to comment and accordingly are, of course, important. The mere existence cannot be used, however, to justify the abstract proposition that in all cases in Scots law, an accused who has been convicted on the basis of a doc identification has necessarily had a fair trial. In Scots law, as in any other circumstance, the actual circumstances of any given trial have to be considered before one can say that it was fair. In some cases, for instance, and then he gives various situations, the last sentence, the effectiveness of these and other potential safeguards in securing a fair trial depends on what actually happened in the individual case. One potential important safeguard lies in the judge's directions to the jury. Indeed, the Lord Justice Clarke saw it as the most important. He then goes on to deal with that.
What does that have to do with Section 57.2 of the 1998 Act?
Well, I cannot answer for what the Lord Roger was thinking when he said that entirely, but what he is saying, I think, is, and we will see it developed, dog identification is not in itself wrong. You cannot say that the very fact that the Lord Advocate leads a dog identification per se amounts to an unfair trial. But the reason for that is there will often be safeguards in place. What one then must do, and what he does in detail, is you look at the safeguards. And if these safeguards were not in place and did not operate as they should have done, then you then have the doc identification without the safeguards. And I think that is clearly his approach in Holland, that you decide it, as it were, looking backwards at the whole circumstances. And if you look at it and say, dog identification, not good, not bad per se, could be good if the safeguards are there. You look at the safeguards. And if the safeguards were not there, for whatever reason, then the doc identification moves into the not good category. And that, I think, is what he is doing. So what is important in Lord Roger's approach, and he looks at them in detail, are the safeguards. Now, what are the safeguards? Because it is important to look at what these are, and they're contained in paragraph 58 and earlier, of course, in paragraph 42. One of them, for example, is the fact that he's legally represented. Well, that certainly happened here. But other safeguards which are mentioned are the existence of other evidence. In other words, if you've got a case where doc identification really didn't matter very much because there was DNA, for example, so the existence of other evidence is a safeguard he puts in. Another safeguard he puts in is the judge's charge. So you look at that as he does in Holland. You would look at the general circumstances of how the identification came to be made. And in my submission, you would also look at whether there had been application of the Lord Advocate's own guidelines on these matters. I'm clear, I think, in my mind that that is the Lord Roger's approach, to say, not good, not bad, let's look at what the safeguards are. And then for what I am doing, leaving aside the McInnes question for the moment, is looking at whether the safeguards operated in this particular case. Now, I say they clearly did not. Was there any other evidence? No, there was not. Indeed, at page 12 to 13 of the judge's charge, he says in terms, without the identification, there could not be a conviction. So this was a case, first of all, which depended, I'm not saying there was no other evidence, but for sufficiency, it depended entirely on the identification. What were the general circumstances of the identification? Again, I can take you to the passages, but it's there. The police officer, Ferguson, was given a name by another policeman of who was guilty. Not clear at all how that came about, how he got the name. But he would certainly know that the man in the dock was the man of that name. The citation to the court would tell him that, if nothing else. He was given the name by a police officer.
You may well be right. Can you just remind me where we get?
Yes, I'll get that found for you, please.
What he said was that he hadn't known his name and got his name from somebody else.
Yes.
In other words, got a name to attribute to
Yes.
the face, as it
Yes.
were.
Yes.
Yeah. But I see. All right.
I'm just simply making the point that he's been given. If someone tells you, it's paragraph 212, I think,
Yes, well, that's what I was-
of the statement of facts and issue.
Yeah.
So it's not just an our statement. So he was given the name, but he doesn't know, I don't think, who gave him that name. Now that must encourage you in your identification when you're given the name. Perhaps not, perhaps that's illogical, but it was certainly not a normal situation, and he was certainly not given an identification parade at all. The second officer was shown a photograph. Now, it's not clear from what we have here whether he was shown a lot of photographs or just one or two photographs, because we never got, as you would get, the so-called emulator sheet. That did not exist in the trial. It was not, we never, or those who did the trial, not me, did not know the detail of how the photographs were.
Did they ask for it?
I don't know that. It's 2003. I don't think they would know that since 2003. One of the problems in this case has been getting the papers from previous people who acted have all
I
gone.
understand.
It's a very, very old case, so I don't know the answer to that. So the circumstances, not just, as my Lord Gill says, there was no identification parade, it goes a little further than that. One was given a name and one looked at a photograph.
Look, well, it's photographs, sir.
On that, against that background, one's looking at the safeguards here that the Lord Rogers exercise he carries out. One looks at the guidelines, the Lord Advocate's guidelines, which, and I'm told there's new ones coming out as we speak, but that's neither here nor there. I've not seen them, but I'm told the new ones are, have you got those? Yeah. And they're contained in Appendix Part 2 at page 104, MS page 192. But it says halfway down that a photograph of the suspect can be shown to witness the purpose of identification. Must be a minimum of 11 other photographs, we don't know about that, of similar age and appearance, etc. If a witness makes a positive identification from photographs, other witnesses should not be shown photographs, but should be asked to make themselves available to view some form of identification parade as described, unless it's not possible. That simply did not happen here. We had witnesses who claimed they could identify and were never given the identification parade. So it's not just, as Malone Gill says, the lack of identification parade. It goes further than that. It is a failure, having been an identification from a photograph, to carry out what should then have happened in terms of identification. So one is...
What's the date of the document, Mr. Jackson?
2007, I think it's later. I think it must be later, I'm sorry.
So it's good practice as now recognised, and you say it should have been understood then
Absolutely.
as well? Okay.
It wasn't. What I'm showing is the good practice. Would always have been good practice, whether or not it's been written down as good practice. I'm saying that what is now considered to be good practice. And why is it good practice? Why do we have the Lord Advocate handing out this sort of guidance? Because there is dangers here, and he specifically wants the good practice to follow. He then looks at the judge's charge, Lord Roger, and says it is important as one of the safeguards to look at that. And I've mentioned that in paragraph 58 already. One potentially important safeguard lies in the judge's directions to the jury. And he suggests what the direction should be. He does go on to paragraph 62 to specifically look at it. So in my answer to the sort of query that Lord Reid was raising, the Lord Roger looks at this as part of the picture, undoubtedly. While the judge gave the jury the usual directions on the need for care in relation to identification evidence, he merely told them that they should remember senior counsel's general point that a doc identification is in her submission not fair and therefore not to be relied upon. All I require of you is to approach all the evidence of identification with great care and circumspection. Whether deliberately or not, the way that this particular direction was formulated might be thought to suggest that the judge was distancing himself from senior counsel's submission on the point. At the very least, neither by associating himself with her submissions nor otherwise did the judge clearly warn the jury of the particular risk of a doc identification in a case where the witness had previously failed to identify the appellant at an identification parade. It is therefore accepted, leaving aside the point my Lord Reid makes, that there are certain directions which it is appropriate for a judge to give, and that was part of what Lord Roger looked at, and indeed what I call the jury manual, which is in the papers, which I take it is handed out to fledgling judges, etc., deals with what judges should say. Even if I may say so, the case of Brodie, which is at tab 1, makes the point that there needs to be very clear directions given, albeit the court was not prepared to go as far as saying what others wanted the direction to be.
Yep.
And you find that in Brodie at paragraph 14 onwards.
Thank you.
And at the bottom of paragraph 18, the trial judge's general direction as to dangers inherent in an eyewitness identification was entirely appropriate. The terms in which he gave it cannot be faulted. But although counsel for the defence did not expressly raise the issue, I think the trial judge should have given a specific direction on the question of doc identification. In my opinion, in light of Holland and the references to it by the Judicial Committee in another case, an express direction on the point is desirable wherever there is a doc identification without there having been an identification parade. I consider the trial judge's failure to give such a direction constituted a misdirection. What should the direction be, he then asks. In my opinion, it would have been sufficient in this case if the trial judge had pointed out to the jury that the person whom D.C. Wilson said that she saw in the car park was not someone whom she knew, etc. And these would all vary in different cases.
Yeah.
You know, those directions are, I think, case-specific.
Yeah, of course.
There was a further submission by counsel in that case, which was rejected, that there should be an even greater direction and matters referred to. I make no point on that.
Understood.
Sorry?
Understood.
I make no point on that further direction, which the appeal court in Edinburgh said was not helpful. If this court considers that the direction should go that far, then of course I will not be disagreeing with that, but it's not a point that I particularly make. So what has happened then is the trial judge's charge has been looked at by Lord Roger and how he approaches it. What is necessary is looked at in Brodie and indeed, as I've mentioned, in the jury manual, and then we can look at what the charge actually was in this case, and that's at page 16 and 17 of the charge, which is in the appendix part 2.
Page.
And it says, in considering evidence of identification, oh, sorry, page 48.
Thank you.
I'm sorry, MS page 136.
Thank you. Yep. Yep.
In considering evidence of identification with particular cases, I have suggested that you ought to do, you're entitled to have regard, bound to have regard to the evidence given as to the opportunity which the witness making the identification had to observe the appearance of the person concerned, especially how close he was to the person concerned, and what the like was, and generally matters of that nature, and submissions have been made to you on these matters. And that, I think, is it, which might have been not uncommon in those days, not for me to say from recollection, but when you look at what Lord Roger says, and indeed what the court said in Brodie, it is clearly not fulfilling the safeguard test which Lord Roger is interested in Holland. So if you look at and take it all together, you get the approach which was taken by Lord Roger in Holland, and I turn now to his final statement on that, which is, did the appellant have a fair trial? Which is at paragraph 77. It is now necessary to consider whether, taken as a whole, the appellant's trial was fair. The fact that he was represented by counsel is a positive feature, pointing towards the trial being fair. On the other hand, the appellant's rights under Article 6 were breached, and then he deals with disclosure, which he deals with at some length. He then deals with the quality of the identification at paragraph 85.
85.
85.
85, thank you.
Yeah.
And he's analysed whether those safeguards were present, generally speaking. Nonetheless, as the trial judge told the jury, the critical issue in relation to charges 2 and 3 was the quality of the identification evidence. Taking all the relevant factors together, I have reached the conclusion that in this case, the failure of the Lord Advocate's representatives to disclose information and the Advocate Deputy's reliance on the doc identification were incompatible with the appellant's core Article 6 Convention right, since taken together, they resulted in an unfair trial. And that, I think, is the point I've been trying to make. This is not about convention right being breached by a doc identification simply, or by a judge's charge not being up to what one might expect. It is not nearly as simple as that. The Lord Rogers approach, which I suggest to this court is the correct approach, is you do not, as it were, would that be enough, would that be enough, would that be enough? It is looking at the whole picture. He says there is disclosure that should have been made. There is doc identification which was made without the appropriate safeguards being in place. And in my submission, that is exactly what we have here. We have these disclosures not being there, although they would have affected how the trial was conducted, and the safeguards of the charge, the circumstances identification came to be made, and the lack of other evidence are not present. And it is when you take them all together that you're entitled to take the view, and should in my submission take the view, that the test, no matter how formulated, has not properly been applied. And I'm back to what has been put down as my absurd point, which is perhaps not the best word I could have used, but I'm stuck with it now, I think. And I think that is the main submission, really, that is when you put it all together in the way that Lord Roger does. And indeed, when one takes Holland and looks at, if I may put it finally like this, if one looks at the lack of disclosure in Holland, on one view, it is less significant than the lack of disclosure here. When one takes the lack of disclosure in Holland, then compares it to the lack of disclosure here, including the fingerprints, the lack of disclosure here is, in my submission, significantly more important than the lack of disclosure in Holland. When one looks at the jury identification, the doc identification, but always does so, as Lord Roger does, in the context of the safeguards, as the safeguards are almost totally missing in this case. The judge's charge is not up to what it should be. There is no other evidence. The circumstance in which they gave it, there is no identification parade. The Lord Advocate's, albeit subsequent guidelines, were not followed. The criticism of the doc of identification is greater in this case than in Holland.
Well, as you explained, we do have one of the officers who appears to recognise him but doesn't know his name. And defence counsel, no doubt for good reasons, don't cross-examine on the nature of his knowledge. And the other one has recognised him from a photograph. So they're not. Neither of them is identifying him for the first time in court.
No, I accept that. I mean, I've no doubt if my Lord was if I say with respect, acting as advocate deputy, these points could be made. These are quite legitimate double-edged points. I don't take away from that. But I'm inviting the court to answer this question. The Lord Roger took the failure to disclose, and he took the doc identification, and putting them together, he reached the conclusion the conviction could not stand. And the question I invite this court to ask, is the disclosure more significant or less significant than it was then? It is more significant. Is the doc identification a bigger problem now than it was then, with the lack of safeguards I've pointed out? It is a bigger problem. How then, I pose the question, can Holland be right, and yet the decision of our court in saying it applied the test also be right? And therefore, for those reasons, I invite the court to take that view. And now I better deal with Cadder, because that certainly was something that was highlighted when we were given the permission to come to this court.
Just before you do that,
Yes,
Lord Reid referred to the Strasbourg jurisprudence in this area, and I'm a little perplexed at what we're being invited by you to do. Our role is a significantly more limited role than that of the High Court.
Yes?
It's analogous, it seems to me, with that which the Strasbourg court would be doing if it were examining a complaint that the trial process had been unfair and a breach of Article 6. Reference has been made to Edwards. We've got Mansell also in the bundle. Authorities 13, where the complaint was treated as inadmissible. Now, this was another non-disclosure case,
Yes.
where the Court of Appeal, this time of England and Wales, had examined the facts in some detail. The complaint was dismissed as inadmissible. We get at MS page 477.
Yes, got that, thank you.
The Court of Appeal examined in detail the prosecution and defence cases, first the conclusions it made, and then the next paragraph, having regard to the extent of the review conducted by the Court of Appeal and the reasons given for upholding the conviction, the Court finds that Edwards' case can't be distinguished on the basis that the Appeal Court's conclusions weren't sufficiently reasoned, and it comes to the conclusion, observes penultimate paragraph, a Court of Appeal had considered for itself the impact of the information which had been withheld, assessed for itself the probative value, and the Strasbourg Court concluded that there had, in those circumstances, been overall a fair trial process. It does seem to me that you're asking this court to go into an examination of the satisfactoriness of the Court of Appeal's conclusion of a kind which the Strasbourg Court was plainly not prepared to do. They looked to see whether there had been a thorough, dispassionate review. You're saying, well, that's not enough. If you're wanting us to, as it were, to dig down into the details and say because they reached, you say, the wrong result, even if there was a detailed independent review, there's still an unfair trial. That seems to me to be asking this court to take a significantly fuller role in relation to factual evaluation than this jurisprudence would suggest appropriate.
I totally understand that. What I am asking the court is to give meaning to the Lord Hope statement, it is open to this court. It must mean something.
What you're saying is that there are cases where the court below goes so wrong they couldn't have reasonably reached the conclusion they did. It comes back to that point, yep.
That is exactly what I'm saying.
Okay.
I'm not saying that every time
No.
the judges, the justices here might think that court was wrong, they can do anything about it. It's a matter of degree, it's a matter of where the line is drawn, and it's very hard to draw a line. But I think the point is clear. I'm saying that
It's rather like the circumstance.
This is over it.
It's rather like the circumstance in which an appeal court can interfere with the finding of fact.
Absolutely.
That's what you're saying, effectively.
I'm not-
it's not dissimilar.
I accept that. I wouldn't say no that one way or another, but I
Well,
accept
it goes a little bit further because there is a statutory bar in the 1995 Act on review of decisions of the High Court of Justiciary. It's subject to the compatibility issue jurisdiction. But the compatibility jurisdiction, as we've seen, is limited to identifying the correct test.
But I'm going round in a circle. If I
Maybe
my Lord knows my answer to that is, I understand my Lord's point, and I think I've answered that as best I can.
See, the thing is, Mr. Jackson, that Lord Rogers' views in Holland, he repeatedly says that we've got to look at the whole circumstances of the individual case.
Yes.
He says that more than once.
Yes.
And that has led you, as I see it, into treating this as a compare and contrast exercise, where you go through the checklist of what happened in Holland, and you say, but look at what happened here. Now that seems to me exactly the process that this legislation is designed to prevent.
Perhaps I've put it blandly. All I'm saying is that the Lord Roger invites the court to look at certain matters, and I'm looking at those matters in isolation from Holland. I do add that this is worse than Holland, but that the compare and contrast, I could do it without doing the compare and contrast. I don't need to compare and contrast. I simply say that taking the Lord Hope's paragraph 25 and the way the Lord Roger dealt with it, what I'm asking this court to do, this court can and should do. And I'm watching time, my Lord Reid, or I think those who allowed us to come here and mention Cadder and the question of finality. Cadder was different in this sense, and this is my submission on that, understand the point. Cadder was saying that if you didn't have access to a solicitor, then there was a miscarriage of justice arose in that situation. Am I putting that too simplistically? Perhaps. That would have been extremely difficult for almost pragmatic reasons to allow every case in history where someone had not had a solicitor to, as it were, be caddered. And I can see almost public policy pragmatic reasons for that. That would have been almost impossible. This is not like that. If, for example, let me put it this way, if, for example, I was asking this court to state that all doc identifications were struck out per se, I'm not asking that. But if I was asking that, and this court were to say, every case with a doc identification is wrong, then that would be a cadder-like change. And you would then open the door which Cadder said you couldn't open, and you would be entitled to keep closed. That is not what has happened.
I mean, it's more nuanced than that, isn't it? It was saying that that the admission of evidence secured from an accused person at a time when he was being interviewed by the police without a solicitor being present was capable of being a breach of Article 6, depending on the circumstances. I mean, for example, if your fingerprints were all over the knife used to commit the murder, the fact that you might have said something to the police without your solicitor being present wasn't going to have been of critical importance.
Can I nuance a little further? It was actually saying it wasn't admissible. It was just saying it might not matter very much, but it was making the statement it was inadmissible, which is perhaps a slight further nuance in the matter.
Yep.
It was making the statement it was inadmissible. I'm not asking this court to make the statement that doc identification is inadmissible. So therefore you don't go on to what you were suggesting. You look at all the other evidence as in Cadder. In Cadder it was a statement of what is inadmissible. That's not what I'm asking for here, and therefore it doesn't have the same effect. and would not have the same, there is no reason, put it this way, in that, as it were, public policy finality argument, in this case, to not look at this particular case, and I say to the court that Cadder is, for the reasons I've just given, a different situation.
Yep.
I think I've finished. Thank you.
Thank you very much, Mr. Jackson. Mr. Considine.
I only adopt the submissions of Madam Senior.
Thank you very much. Mr. Brown.
My Lords, my Lady, there is one, I'm afraid, one factual matter that has caused me a little concern, which is the reference to the fingerprints being on the passenger side. That was not, as I understood it in the statement of facts and issues, and rather more, it was simply that it was on the mirror. That aspect of my learned friend's submission came in his written case, but I am afraid remain unclear as to where the basis for that submission stems from.
Or perhaps you can have a word about it over the short adjournment.
Well, I simply make the point.
Good, I understand.
As to draw attention to it so
Yeah,
that
no,
a friend can address matters.
Thank you.
In terms of the statutory footing for the appeal, I take no issue with the assessment that has been carried out. And as your Lordships have already heard, in terms of the case that was taken by the applicant, there was a devolution issue raised, which is within the papers. It reflects the two grounds of appeal that have been focused on today, which is non-disclosure and doc identification. There was, of course, a third ground of appeal, which related to the charge in terms complaining of its submitted failings. And that, of course, is dealt with separately by the appeal court because it was never a devolution issue. It is simply a miscarriage of justice in the domestic sense. And that may raise some tensions with the submission that has been made in terms of Holland, that the importance of the charge is as significant as Mr. Jackson suggests. I simply highlight that in terms of the practical background to this case. My learned friend suggests that, of course...
Can I ask a practical question?
Yes, Eddie.
In a lot of cases in England, especially if there's any difficulty about what directions should be given to the jury, the trial judge has a discussion with counsel and invites them to help with what those directions should be. And of course, they're rather frequently written down as well.
Yes.
Now, is that in any way the practice in Scotland? I'm not saying it should be, I just want to know whether it is.
If I could put it this way, the answer is, I think, sometimes, but very much dependent on which judge is hearing a case.
Oh, not depending on the type of case?
Well, I think the starting point is whether a judge would be inclined to ask counsel. In a more complex case, then, yes, no doubt, the prospect of that question being asked engages more obviously. I have to say, in terms of this appeal, given the trial judge, Lord Morrison, I don't imagine that that question was asked. Because his own views will have been fairly firmly set in his own mind, I would imagine.
What else can we deduce about the trial, Mr. Brown? If, for example, counsel had taken the point with the jury that the identification of the police officers ought to be treated as unsafe or at least unreliable because it was made in the dock, would you then have expected the judge to deal with that in the course of his charge or not?
It would be more likely, one would have thought, that if a specific point is raised by counsel in a speech, that the trial judge, in considering what were appropriate directions, might well take account of that.
I mean, quite apart from the business of asking counsel for general help about...
I think if there's a keystone to the defence submissions, and in fairness, the trial judge in the charge one sees, I think it's fair to say that both the Crown and the defence positions are made quite clear.
Well, that's what I was wondering.
And to that extent, I think in this case, and it's perhaps reflective of the time of the case, that the issue of doc identification was not as focused as it is now, and has been focused in later authorities.
Yes, I see.
But also, and your lordships will have seen this in the Crown written submissions, that of course the essence of this case was the identification of the two police officers. The learned trial judge makes quite plain, if you don't accept that, then this trial is at an end for practical purposes. And of course, as alluded to, and I don't wish to get into the facts, if at all possible, because they're all set out in the written submissions. The oddity of this case is the defence is founded, in part at least, the alibi is separate, but it's founded at least by two witnesses positively saying the man in the dock is not the accused. So from a jury perspective, the issue is quite clear. Is the identification of the police officers correct? If doubts are raised, then that is an end of the case. And if I may at this point just simply touch on the identification, because your lordships have mentioned this, of the two police officers. I note what was said about the name being given, and of course it's so easy to associate with the name of the accused in the indictment. That would be true in certain circumstances, but that is not the position here. The position is he was putting a name to a face that it would appear was already known. The other officer, in terms of the photographs, your lordships have various statements within the bundle in Appendix 2. And your lordship will see at tab 14, lordships will bear with me, the statement, sorry, it's MS 159.
Sorry. Do you say we should be looking at this at all?
No, I don't. Your lordships will have seen the written submissions. The Crown's starting position is it is manifest that the McInnes test, the test that had to be applied, was applied.
Yes, that's why I was wondering why we were looking at. But this is your fallback argument, then?
Yes, absolutely.
Okay.
I'm sorry, it was simply because we were talking about the charge, it seemed convenient to introduce this matter. And if I may simply conclude it, because I don't have to say much more about the facts.
Fine.
It's simply that the issue of the photographs was raised by my learned friend.
Okay.
At MS 159, you have the statement of Simon Neil Reid, the officer who was shown the photographs. At MS 161, at the end, you'll see that it's set out. He was shown a selection of photographs by Detective Constable Harris, who was corroborated by witness Sergeant Chambers, and identified the male person responsible as image number 2, which I later learned was that of accused Macklin. It would appear that it is not just a photograph, it's a selection of photographs.
Well, if you look at the next line, does it follow that the selection was exhibited?
It was not a production in the case, but it would appear that that was the intention from the terms of the statement.
Yeah.
But that didn't proceed.
Available if one asks for it.
Yes, I think it's reflective again of this being 2003 rather than now.
Okay.
But I simply highlight that because it makes the point that this is not a first identification in the dock. Yeah. In the classic concern about dock identification. But, having dealt with a number of factual matters, it is my respectful submission that what your lordships are being asked to do is to review, in essence, the decision of the Court of Appeal. That is not, as has been discussed, the function of this court. And in my respectful submission, the appeal on that basis comes to an end simply because the matter has been addressed by the application of the correct test. The conclusions drawn were a matter for the Court of Appeal in Edinburgh. And even if your lordships were to the view that their conclusions were to be different from conclusions you may well have reached, that is by the by, given the statutory framework that your lordships operate under.
One of Mr. Brown, one of the questions that my lady asked, I'm not sure you answered, but I think you'll be able to confirm that judges are and were in 2003 issued with a jury manual, as it's called, which contains model directions.
Yes.
And those directions in 2003 would not have included anything specifically about dock identifications.
No. I'm sorry, my lord, that is in the written submissions of the Crown. The point is made that there was a jury manual, and and I think the point is made that there was no appeal taken in 2003 against the charge itself, which is reflective, if I may suggest, of the fact that the charge of its time was seen as being correct.
I think I can give evidence here.
Well,
the jury manual in those days, which I can just recollect, was concerned with the dangers of wrong identification in general. And those words from Lord Morrison were taken from that passage, but there wasn't anything special. It wasn't till Holland that dock identification was put on the map.
Yes, I mean, what other members of the court would know as Turnbull directions would have been contained in the jury manual?
Yes, because that of its time was the standard following the jury manual of the time. I simply confirm that. And in that regard, and I'm sorry because the point has been made that practice changed after Holland in the same way, and I'm sorry to go back to factual matters, but it's useful to touch on it now. Criticism is made of the fact that in 2015 the matters that were not disclosed in 2003 would have been disclosed. That is not recognising that they are all material, but is simply reflective of the practice of the Crown to disclose, I think, speaking simply, as much as is humanly possible to avoid the very situation we're in today. And your lordships will recollect that this court in MacDonald made the point that the Crown is disclosing more, and this is going back a few years, than it actually has to in terms of the test.
In England, the problem's almost gone full circle because the problem which is now identified about disclosure is that too much is being disclosed.
Well, I think that is not entirely uncommon north of the border
It's
too.
mainly, of course, in large cases rather than this sort of case.
Yes.
But that is undoubtedly a problem.
Well, it is a problem, and I have to say that there's a general concern with masses of disclosure, how much is actually ever considered. But that's a separate issue. My learned friend was in essence saying the Court of Appeal would never just pay lip service. But I respectfully invite your lordships to the conclusion that that is essentially what he then went on to do by criticising the approach taken by the bench in Macklin. As your lordships have noted under reference to paragraphs 33 and 37 of the decision, it is tolerably, if not absolutely clear, that the test in McInnes was in the forefront of their minds, and that is the test that they applied. There's little more that I can usefully say to say I would recognise that if there were ever a case where it could be demonstrated that lip service had been paid, it might well be a case where your lordships could interfere. Yes. But shortly put, this is not it. And in that regard, looking to the language of Lord Hope, bear with me. In paragraph 25 of McInnes MS 369, the start of that paragraph reads, although I suggested the description of the test which the Lord Justice General gave at the end of paragraph 20 was incomplete, it is clear from the discussion that follows that the test that the appeal court actually applied was the correct one. As I've already observed, it is not for this court to say whether the test was applied correctly. Looking at the starting point in the context of that paragraph, the difficulty faced by the court in McInnes was looking at the lower court's observations, it wasn't entirely clear that the test had been applied until, because it didn't say so in terms, but then one looked at the way it was approached and it was confirmed that it had been. That, in my respectful submission, mirrors what has happened in the case of Macklin, standing the assessment of the court in its written opinion. They do not say in terms, although it's, in my respectful submission, tolerably clear from the Crown's invitation and the whole tenor of the appeal that the issue was McInnes, that is exactly what they have done. And with the greatest respect, I regret I really can't take the matter very much further. Your Lordships have the submissions, and that remains the Crown's response. I don't know if there's any particular issue in relation to that you would wish to.
Well, that's very helpful. Thank you very much indeed.
Yes.
Thank you, Mr. Brown.
In terms of doc identification, then, in my respectful submission, looking to doc identification, my learned friend has conceded that per se it is not inadmissible, and obviously the safeguards discussed in Holland are well known. Looking to Holland, and I'm sorry to be a little repetitive, I recognise and accept that the authorities show the proper approach is to consider whether, having regard to all the elements of the proceedings reading from paragraph 41 MS 325, including the way in which the identification evidence was obtained, the accused had a fair trial in terms of Article 6. In my respectful submission, looking to the facts of this case and recognising that there were not specific directions about doc identification, my respectful submission is that, against the background which I've already alluded to of the factual position, doc identification in this case cannot be seen as, in any sense, out with the proper admissibility test. And therefore, again, in terms of the assessments made by the Court of Appeal, using McInnes, in my respectful submission, the same conclusions can be reached.
You would accept, presumably, that admissibility is a separate question from the fairness overall of the trial.
Of course.
Lord Roger was making it absolutely plain in Holland that a doc ID would, in most cases, in all but extreme cases, be admissible.
It would be admissible, and then
but you then have to look at that in connection with everything else about the trial,
yes,
to see whether overall the trial was fair.
Just so.
They are two separate questions.
Oh, I'm sorry, of course there are two separate questions, and admissibility is entirely, of course, for the domestic court rather than this court. But in terms of fair trial, the lower court has considered, obviously, the safeguards. And in my respectful submission, looking to the facts and circumstances of this case, there were a number of safeguards at play which adequately addressed any concerns that might be raised. Primarily that this was a corroborated case, the defence were aware, could cross-examine not perfunctorily.
In Scotland, does the judge in a criminal case have a responsibility analogous to that which a judge has in England and Wales, now on a statutory basis, to exclude evidence if, even though technically admissible, if the prejudicial effect would outweigh the probative value?
Don't think so, my
lord. No,
certainly no statutory footing to that extent.
No analogous regime.
I suppose that one would say if one were in that sort of extreme territory, one might well expect a judge to raise the issue.
Right.
But that's not obviously on the same footing.
Thank you.
So there was corroboration. There is instructed defence counsel rigorous cross-examination, because this is the point of the case. And what is being suggested by the defence, in addition to the alibi, is that the police officers were mistaken. By contrast, as the trial judge has alluded to, in giving them, where I would submit, are adequate directions, and therefore another safeguard to be taken into the totality of the circumstances, emphasis that identification is key, and that the various factors are at play, including the amount of time that the witnesses had to look. And my learned friend talks about that, but my respectful submission, this is very far from the fleeting case. This is a case where, over a period of minutes, there are repeated face-on, from the statement of facts and issues, views of a man who is pointing a gun and is submitted in the Crown's submissions. The fact that these are police officers who are having repeated views might be seen as a strong factor.
I suppose, in answer to my Lord's question a moment ago, there are particular contexts one can think of where that sort of exercise would be carried out. I mean, I'm thinking, for example, under statute in relation to the admission of evidence about the previous sexual history of a complainant in a rape case.
Yes.
For example, there would be an assessment of whether the prejudicial effect of the evidence might you're required by statute, I think, to balance that against its its relevance. And so,
I think the point about that, my Lord, is that would have the 274-275 issue, which is the provisions of the 1995 Act, which address what is admissible in the context of character, if I speak simply. That should have been determined before the trial, which is perhaps the distinction.
Yes, and similarly, I mean, there can be questions about the admissibility of irregularly obtained evidence, for example, where the court carries out an assessment of the fairness of admitting it.
Which would be a hearing of evidence prior to the trial taking place itself. So in Scotland, these matters, I think, ideally should be determined in advance of any trial hearing, so it shouldn't arise in that context.
Yep.
I think, my Lords, in the round, the Crown's submission is both in relation to the doc identification and the disclosure, and looking at those together. The decision of the Court of Appeal in Edinburgh was one that applied the right test. But the conclusions the Court of Appeal arrived at are not for your Lordships to review. It's not your purpose. And with the greatest of respect to my Lord's friends' submissions, notwithstanding them, this appeal should be refused. Because it is not a matter, it doesn't raise matters that in the end of the day are actually matters that are for your Lordships to properly determine. I think your Lordships have the Crown submissions in writing, and they can't be added to unless I can assist your Lordships in any particular way.
Thank you very much, Mr. Brown. Thank you. Ms. Gray, anything to add?
I adopt the submissions of my learned
Thank you very much. Thank you. Mr. Jackson.
Bit of perhaps interest. My Lord Coulson asked about whether or not judges do certain things and take away admissible evidence, and the answer to that is they do on occasions, but not very often, and certainly not on a statutory basis. The one example I can think of is if you have two accused, evidence may be admissible against one, but not against the other, and the normal way to do it is to admit it and then tell the jury it's not admissible against the other. But on occasions, that is so prejudicial to one compared to the probative value on the other that a judge will take the balancing act and strike it out, although it is admissible. As to whether or not judges ask counsel's opinion on the charge, where it happens a lot, in fact, I think it must happen, is where a judge is thinking about removing culpable homicide as an option for the jury. In a murder trial, they might be thinking, am I going to allow the jury to find a verdict of culpable homicide here? I think in general terms, they will never take that away without asking for submissions on it. I think that's right. So these things do happen. As far as the submission is concerned, the Crown submission is, of course, admirably simple, which is, this is really not the business of this court. As long as the test is applied, it is not the court's business. And I understand that. What I do say the Crown answer doesn't do, it doesn't help us to understand what my paragraph 25 means, which is it is open. And nowhere has that been analysed. And when I say it has to be viewed as paying lip service, perhaps that is what I am saying, it doesn't analyse the reasons I'm saying that. I understand the Crown submission, but in my own submission, it doesn't really deal with the issues.
Thank you very much. Grateful to Council for dealing with this matter economically and clearly. Thank you. We're grateful to those who were involved in preparing the written cases as well. We will consider this matter and let you know our decision in due course. Court is now adjourned.